In March 2020, Manuel Ellis died while handcuffed in police custody. 3 officers involved in the incident are on trial. Officers Matthew Collins and Christopher Burbank face second-degree murder and manslaughter charges. Officer Timothy Rankin is charged with manslaughter. All 3 have pleaded not guilty. Thank you for joining us. I'm Christine Pei. Now, for the duration of the trial, King 5 will recap the biggest developments in the courtroom, and we will discuss what it all means. Today, we sit down with attorney Mark Lindquist, who served as a Pierce County prosecuting attorney for nearly a decade. Also joining us is retired Pierce County Superior Court Judge Brian Tollefson and public defender and vice dean for intellectual life and professor of law at Seattle University, Deborah Ahrens, joins us again this week. Thank you all for being here, of course. But first, let's check in with Tacoma Bureau Chief Lionel Donovan about what happened in court this past week.
This week, the defense wrapped up its case with testimony from 2 of the charged officers. Matthew Collins and Timothy Rankin both explained to the jury what they remember the night they encountered Ellis.
Somebody swear or affirm that your testimony.
The week began with testimony from Tacoma police officer Matthew Collins. Collins, an 8-year veteran of the department, said he drew on his training as a police officer, soldier, and grappling expert, as well as his experiences patrolling Tacoma's high-crime areas. He said he and Christopher Burbank encountered Ellis in the middle of the intersection of 96th and Ainsworth. Collins says when he got out to investigate, a struggle began soon after.
So as soon as I get to the front of the vehicle, he takes his focus off of Burbank and comes right at me and grabs me by my vest and picks me up and throws me backwards into the intersection.
Collins also testified that he did not hear Ellis say he couldn't breathe, despite the statement being heard on witness video.
Truth, the whole truth, and nothing but the truth.
Officer Timothy Rankin did testify that he heard Ellis say he couldn't breathe multiple times and told Ellis, quote, "If you're talking to me, you can breathe just fine." He also told Ellis that if he stopped struggling, he would release some of the pressure, because at that point, Rankin had both of his knees on Ellis's back, pressing down. But Special Assistant Attorney General Patty Eakes also questioned Rankin about what he didn't say.
But you never asked him, are you okay? Are you able to breathe?
I think Mr. Ellis wasn't talking to anyone.
But did you ask him, officer?
I did not.
On Wednesday, as prosecutors cross-examined Rankin, the defense took issue with an exchange between Eakes and Rankin. Defense lawyers argued Eakes was out of line for indirectly asking if Rankin had a lawyer present during an audio interview he conducted several days later, information deemed inappropriate for the jury. The defense claimed Eakes was attempting to force a mistrial and called for the judge to dismiss the charges against the officers. However, Judge Brian Shushkoff disagreed.
All errors do not make a mistrial or a dismissal. I don't think she did it for the purpose of achieving a dismissal. Because of that, I don't think there's any reason, or to achieve a mistrial rather. And for that reason, I don't think there's any reason for the court to think the state did this in order to get a do-over.
The third charged officer, Christopher Burbank, stated he will not testify. Since the prosecution will not be calling in witnesses to rebut the defense's case, court is in recess until Monday, where the jury will be brought back in to hear instructions and closing arguments. From the Pierce County Courthouse, Lionel Donovan, King 5 News.
So let's get deeper into this. As Lionel said, this week we heard from the last 2 witnesses in the defense's case, defendants Matthew Collins and Timothy Rankin. The third officer, as you just heard, Christopher Burbank, decided not to testify. So Matthew Collins appeared on the stand first, and here is a moment from his testimony.
How was the death of a sudden community contact affected you, Officer Collins?
I mean, for police officers, it's the worst thing that can happen. I mean, in this case, undoubtedly, Manny was in the wrong. But at the end of the day, his mother lost a child, and his sister lost a brother, and that human life is a precious thing. And so, obviously, it's a weight we bear as police officers when we go out and we step into this stuff every single night. But it's the worst possible outcome.
So let me direct this question to everyone. Taking a look at the testimony from Collins, what stood out to you the most? And I'll start with you, Mark, for your initial reaction on Officer Collins' testimony.
Well, when evaluating a witness, I look at both the substance and the style, because how they present affects how the jury interprets the substance. As to the substance, what Officer Collins did is explain how the incident started. Only 3 people know, and obviously Mr. Ellis cannot testify. Officer Burbank chose not to testify, so Officer Collins is the man who gets to explain how the incident started. But more importantly than that to me was how he presented. And I've always said he needed to get up there and show some remorse about what happened. And he did that, and we just actually heard him talk about the fact that no matter what, a mother lost a son, and all human life is precious. I think that needed to be said, and it was important he got that out there, as important as anything he did.
You know, by this time in the trial, I'll direct this to you, Deborah, we know a lot of the facts of the case already, but this is the first time we're hearing the demeanor from the officers, the first time we're seeing Officer Collins react. What were your thoughts?
Well, this has always been a case that is going to come down to who the jury credits, and it's not going to come down to the expert witnesses. It's going to come down to whose story do they believe. And the defense actually has a lot less of a burden here than the state does. The state has to be believed. The defense has to be believable. They have to offer a story and offer it in a way that the jury can credit and have reasonable doubt. And I do think that Collins was very calm during his testimony, responded appropriately, did show some remorse, and I think that if the jury is looking to believe him, he presents in a way that makes it so that they can consider him believable, whether or not ultimately they believe his story.
Sure. Well, let's focus in on one part of Collins' testimony. There was a bit of a back and forth between the defense and the prosecution over what Collins remembers hearing from that night and even what he remembers saying. Prosecutor Patty Eakes asked Collins if he was the one who told Ellis to, quote, shut the F up after Ellis is heard on witness video saying he couldn't breathe. Collins said he did not remember saying it, but that if it was said, he would have been the one to say it, since Officer Burbank does not swear, according to him. So do you think the prosecution was effective in pointing out any inconsistencies in Officer Collins' testimony during the cross-examination?
I do think that is something that probably the prosecution will be highlighting in closing arguments. That is a difference. I wonder if a lot of people have had the experience of living through a very traumatic encounter and then afterwards not remembering it particularly clearly. And so I can see either way, right? The jury could say it's really not particularly credible that you wouldn't remember saying things like that and you wouldn't remember some of these very upsetting things that you would have heard. But on the other hand, I think that many people have the experience of not completely remembering something very stressful that they've experienced.
Just as a former prosecutor, Mark, how do you think the cross-examination went?
If I were the prosecutor, I would have left that one alone because I think Officer Collins scored points with the jury by saying, I don't remember saying it, but if someone did, it was me.
Yeah.
He got to vouch for his partner too and said, my partner's a choir boy. He doesn't swear.
Well, that's a good point, and it makes him look out for him in a way. He's putting the blame on himself in such a way. Maybe that would make him seem sympathetic, perhaps.
Exactly.
What were you wanting to say?
Well, I was just going to say, from a judicial perspective, these are all just issues for the jury to decide: credibility, believability, all that. So there's nothing really for the judge to do just to make sure that it's a fair trial. But from a non-judicial perspective, I think Collins was very professional and is very polite, very respectful to Ms. Eakes, and everybody's.
Certainly.
So I think he came off. I'm getting out of my judge role here.
Yeah.
I think he came off real genuine.
Sure. Well, yes. Go ahead,
Yeah,
Mark.
Christine. One thing I was going to add to that is the other thing that Officer Collins said was that he had 4 children. Mm-hmm. And you may not think that on its face that's particularly relevant. But just like the prosecution wanted to dehumanize Mr. Ellis, the defense wants to humanize Officer Collins. Yeah. And when he starts talking about his children, I remember thinking, oh, I have a daughter about the same age as his daughter. And those are the kind of things that connect with jurors.
Right, and they were kind of going into his time in the military as well, bringing up his medals and his accolades as well. So certainly I can see that was an image that they were trying to paint when it comes to Officer Collins. Another topic that the defense touched on heavily was a separate incident before Ellis, actually, when Officers Collins and Burbank fought with another person they say displayed the signs of quote, excited delirium. They described the suspect as having superhuman strength. They also said it seemed impossible to cause him pain. So here is Officer Collins describing that part, a part of that confrontation.
It was one of the scariest experiences I've ever had. But the strength that this guy had, he was very small. He was probably 150 pounds, kind of skinny. But he was whispering to us the whole time that he was going to kill us. And he was throwing me around with all my body weight on one arm, and he was slamming me into the wall and throwing me around. And at one point, I kneed him in his groin as hard as I possibly could, and he started laughing.
So this confrontation is very similar to the way Collins described the fight with Ellis. He said this previous fight was part of his, quote, Rolodex of experiences that he uses to inform his decisions. As the defense emphasized several times, Collins is an experienced officer. So the examination on this part was pretty extensive. It was a pretty long time that they were talking about an entirely different case outside of Ellis. Why do you think they chose to focus so much on that incident with someone who was not even Ellis?
I mean, I think that they're trying to figure out what intent the police officers would have during this encounter. And so if what the officers are saying is based on our past encounters, this is how I reasonably perceived the situation and therefore how I responded to it, they're entering that situation with a different intent than if they don't have that background. And so I think that's why the defense is highlighting it.
Could there have been even any grounds for that to be struck down for relevance even? I mean, we're not even talking about Ellis, but it was his past experience. Do you think this helped Collins when he was talking about a past experience, or could his years of experience have actually potentially hurt him in the eyes of the jury?
No, I think that helped Officer Collins to, as Deborah said, it puts his use of force in context, because the test is both objective and subjective. Is your use of force reasonable? But you have to look at it through the eyes of an officer who has experienced and seen what this officer has experienced and seen. And to answer your other question, Judge could have kept that out. Judges have a lot of discretion. But Judge Shushkoff, and as I said, I've tried cases in front of Judge Shushkoff, and he tends to let both sides argue their theory of the case.
I gotcha. Okay. Well, let's turn to another very important testimony that we heard through this week. Officer Rankin testified after Officer Collins. He described the moment he heard Officers Burbank and Collins' mic clicks over police radio. This was the night Ellis died, and also driving up to a situation where he wasn't even completely sure what was going on. Let's take a listen.
What's going through your mind at that point when you're hearing that?
I think Officer Ford and I think we both, we knew it was a physical altercation just because of the frequency of the mic clicks, how many mic clicks. To me, as a new officer, it signified someone was trying to go for their hand mic to call something out, but they are unable to.
And are you and Ford saying anything to each other on your way there?
I think there was a little bit of discussion back and forth about what's going on. But I think for the most part, we were trying to keep quiet to listen to what all was happening over the radio.
So let's dive into Officer Rankin's testimony. I'll open it up to everyone. What were your initial impressions? I mean, there were a couple of moments when he became emotional. What do you think? How do you think he did, basically?
I mean, again, he needs to come into this and be believable. And I think that part of offering the information about the mic clicks and so forth is even if he comes in personally mistaken about the situation he faces, he's trying to establish that it's reasonable for him to have been mistaken and to have perceived the situation to be unfolding in a particular way that required the force that he used. And so I think that he established that story, and that was what he was trying to establish with his defense.
Yeah.
When we think of the contrast between Officer Collins' testimony and Officer Rankin, they were very different.
Yes.
Collins exuded, I mean, he seemed more confident, whereas Rankin was, perhaps portrayed as a rookie officer who was just, beginning his career with the police department in Tacoma. What were your thoughts, Mark?
Exactly that. Officer Rankin was not as professional and composed as Officer Collins, but he was empathetic, vulnerable, He choked up a couple times, as you said. And I think in many ways he may have been more sympathetic and accessible to the jury.
Right.
He came across as what he is, a young rookie.
So,
And he made some,
yeah.
key admissions that benefited the state. So I'm sure the jury's going to take that into account and say, well, he told us, he heard this, I can't breathe, a couple of times. So that kind of establishes more credibility.
Well, we are now finished with basically both sides have rested their case. We've heard from all the experts, we've heard all the facts and all the prior statements made to detectives. But now we're for the first time hearing from the officers. Do you think that they were portrayed as likable? I think that at that point, was the defense at least successful in that? Because at that point, the jury might be thinking, hey, do I like these guys? What will it be like to convict them of what they are charged with? I mean, is that kind of going through the defense's mind at this point?
I think in this particular case, as a defense attorney, you would have spent a lot of time practicing questioning with your client and trying to needle them and provoke them, because this is a case where part of the state's theory is that the officers overreacted, were temperamental, right? Used force when they were not supposed to use it. And so it was pretty important that they not respond temperamentally in court. And I think that they did that. They responded differently, absolutely. I think that it may in part reflect not just that Rankin is a junior, relatively rookie officer, but also that he probably has a lot less experience testifying in court. And if it's a new experience for you, no matter who you are, that's going to be a stressful experience. And so I think maybe the difference in testimony reflects, and the difference in demeanor in partly reflects that level of experience also.
Certainly. Well, let's turn now to a question that appeared like it would derail the trial. This occurred when prosecutor Patty Eakes was cross-examining Officer Rankin. She was asking him about an interview that he gave with the Pierce County Sheriff's Department. Let's hear that moment.
Mr. Rankin, you gave a statement about this case on March 6, 2020, correct?
Yes, ma'am.
And you knew at that time that Mr. Ellis had died.
Yes, I did.
And you understood that this was a death investigation into what had happened to Mr. Ellis on March 3rd, 2020, correct?
Yes.
And you had 3 days to be able to consider and counsel before you went in for this interview, correct?
Can you counsel? I don't know what that means.
You had other people with you in the interview, correct?
So what's happening here is Prosecutor Patty Eakes suggested in front of the jury that Rankin had contacted a lawyer before he spoke with investigators about the night Manuel Ellis died. And after that happened, all three defense teams asked for the case to be dismissed. The judge agreed that that was not something that Eakes was supposed to have said in front of jurors. However, he declined to dismiss the charges or declare a mistrial. So, Judge, for some people who are watching this play out, could you explain what this is? What's been happening here?
Okay, well, defendants have certain rights, and the right to counsel is one of them. The right to remain silent is another one, and you're never ever supposed to mention those things in front of the jury, unless somehow the defendant has opened the door to this line of questioning, which didn't happen in this case. So the prosecutor was using the word counsel, and the judge decided that the use of the word counsel meant attorney,
sure,
not counseling or something like that. And he was very concerned, but at the end of the day, he decided that it wasn't intentional, and if it wasn't intentional, it was very kind of off. It was kind of a slight statement, you know what I mean? It wasn't very focused, in my opinion. So the judge was very, gosh, there's a lot of time and effort and work on this case, and I don't think she was being intentional in doing this, and so motions to dismiss denied.
One of the defense attorneys even went so far as to claim that Patty Eakes was trying to intentionally trigger a mistrial. What were your thoughts when that was said? I mean, what was your reaction when you were seeing all this play out? Was it pretty shocking?
Well, my first reaction was prosecutors know you cannot mention the defendant's right to counsel. Right to counsel is almost sacred in the U.S. system. And so it's drummed into the prosecutor's head, just stay away from that, because you cannot suggest that the jury should infer guilt from a defendant talking to an attorney, hiring an attorney, or even wanting an attorney. So I was surprised to see in a high-profile case like this a prosecutor stray into that area. Now, that said, I agree with the judge that it was a very soft stray into that area. I agree with Judge Tollefson, but I also agree with Judge Shushkoff, who found it was not intentional. But what was most surprising to me was not so much the accusations from the defense, but rather the 2 of the 3 defense attorneys said, well, we could ask for a mistrial, and they almost always do under those circumstances, but they did not.
Yeah.
They think they're ahead. They think they're winning.
Yeah. Could you touch on that actually a little bit, Deborah, how common it is for that to happen from the defense lawyers?
From a defense lawyer's perspective, if I think that there's been an error at trial, particularly a potential constitutional error, I would ask for a mistrial because that's the best way to preserve the issue, the best way to draw attention to the issue, the best way to get it reviewed on appeal. And so generally I would. I think that you're right, that likely the reason that the other 2 defense attorneys didn't ask is because what they're hoping is that this trial that they've already invested in ends in an acquittal, and they won't need to do that, and they would prefer not to restart.
And they feel confident about it. You just touched, I'm sorry, go ahead, Judge.
No, I was just going to say, sometimes these issues get in front of the appellate court, and at that stage, you're going to have to see what the appellate court would say. Sometimes they'll say, well, you're right, it was a violation of the constitutional right, and you should have stayed away from this, but harmless error. So there's always that.
Right.
Well, could you touch on that? Could you explain for our viewers that in order for there to even be a consideration of an appeal, did that motion to have a mistrial that it has gotten in, at least from one of the attorneys, is now in. So does that open the doors for a potential appeal if there is a conviction?
They can appeal either way. It's easier to get your errors reviewed if you do highlight them and preserve them for appeal, but a reviewing court could still review any error that occurs that, with respect to the Constitution in particular, on appeal.
Sure. Okay, so let's actually zoom out and take a broader look at the defense's case. For the state to convict, they need to prove their case beyond a reasonable doubt. So do you think ultimately that the defense has sown any doubt among this jury from the entire trial that you have seen so far? How do you think they've been doing?
I mean, I think the fact that the officers testified and were able to testify in a way that, as I said, can be believed or is potentially believable, the jury just needs to have a reasonable doubt. They need to be concerned that the officers could be telling the truth, not necessarily that they are telling the truth. And I do think that the defense has offered enough that if the jurors wish to find reasonable doubt, it's there for them to find.
Your thoughts, Mark?
After watching the testimony of the officers, I don't see how the jury is going to come back with murder convictions. So we're left with the manslaughter charges. And the interesting thing about manslaughter is usually we deal with manslaughter in our civil system rather than in our criminal system. You know, for example, I have a case against Boeing where they killed 346 people through their negligence. But they're going to pay huge fines, they're going to pay off massive lawsuits, but nobody's going to go to jail. Sure. So one of the hurdles here for the prosecution is asking the jury to send these officers to prison for negligence.
I see. Kind of going into the Officer Burbank, Christopher Burbank. We did not hear from Officer Burbank. You had predicted that we would hear from all the officers. What might the strategy have been in having him? I mean, it sounds like ultimately he chose not to testify. Right. Do you think this hurt his case or might have helped him?
I stand by my opinion that the jurors wanted to hear from the officers. This is one of those areas where I think police officers are maybe at a disadvantage compared to other defendants. Because they're public servants, I think the public expects them to explain their actions. Yeah. And I think the public is justified in expecting officers to explain their actions. But a couple things going on, I think. Number one, I think everyone knows that Officer Burbank became ill and that delayed the trial. And you don't want to put a client on the stand who's not in peak performance mode. And secondly, getting back to what we discussed earlier, the defense thinks they're ahead. And if you think you're ahead, you're less likely to take the risk of putting your client on the stand.
Sure thing. And looking ahead to next week, closing arguments, we can hear from both of them, recapping everything. What should each side really focus on at this point, would you say? What do they really need to hit?
Prosecution needs to go back to their theme, the I can't breathe.
Yeah. That was the one that was from day one. That's what they were talking about. That is for sure. What about you? What in terms of the defense? What do you think they need to?
I mean, I think that they need to focus on the officers' stories and point out that the officers entered this encounter, that the officers believe that they were using a reasonable amount of force in response, and that the officers testified credibly, at least in their view, about what happened during this encounter. This is really going to come down to who do the jurors credit, which set of eyewitnesses do they credit, and I think that the defense needs to persuade the jury that they can credit the police officers.
Sure. Well, go ahead,
I was
Judge.
just going to say that, of course, the jury's going to get at least one jury instruction about what beyond a reasonable doubt means. And a lot of times I see in closing arguments, attorneys will say, okay, it says right here what reasonable doubt means, and then they go through the evidence to show why they think there's reasonable doubt if they're a defense counsel. And on the other side, the prosecutor goes through there and says beyond a reasonable doubt in the other direction.
Yeah. Well, after the closing arguments next week, the jury will be deliberating, but going into some legal rules, Judge, just to get an idea of how long this might take. How long can the jury deliberate before they potentially declare a mistrial? How long might this process take? Yeah. We're heading into even the Christmas holiday coming up pretty soon. What do you foresee or predict?
Well, I think the judge is going to give them some time. They've had a long, long trial, a lot of information to digest, and so I think the judge is going to give them some time. Even if they send out messages saying, you know, we think we're deadlocked, the judge will bring them out into the courtroom and poll the jury, sometimes individually, sometimes just the presiding juror will get polled. But at the end of the day, I think the judge is going to give them some time, even if they say they're deadlocked. I think, you know, there's a lot of time and effort invested in this case, and judges have some discretion in this area.
Sure. Any final thoughts, Mark and Deborah?
No, I would expect that it's possible the jury will be out for some time. They have 3 different defendants, which is important to keep in mind. It's not one defendant, and all 3 officers aren't necessarily similarly positioned, and they really do need to make sure that they're discussing the evidence with respect to each officer specifically, as opposed to considering them collectively, even though I imagine some of that will happen as well.
Right.
But yes, I think the judge has communicated that this is a trial in which the parties and the court and the jury itself have invested a lot of time, and would like this jury to reach a verdict.
Certainly. Mark?
I've long thought a hung jury was a high possibility, but I think Judge Tollefson is right, which is the judge is going to send it. The first time they come back and say they're hung, the judge is going to say, go back and deliberate.
Yeah.
I suspect the judge is going to send them back 2 or 3 times in hopes they can reach a verdict.
Okay, we shall see. Yes.
Well, I was just going to say, one of the other puzzles in this case is going to be how they handle some of this demonstrative evidence, because some of the things that the jury saw were not substantive evidence, they were demonstrative evidence, and I don't know how that's all. I anticipate there's going to be some on-the-record discussions with counsel and the judge and I expect the jury is going to send out a note, you know, we want to see thus and so, and that might have been a demonstrative exhibit that wasn't intended to go into the jury room. So we'll have to, I'm sure we're going to hear some more things about what goes into the jury room, what doesn't go into the jury room, and what the jury can consider.
That will be the process ahead. Well, thank you so much, everyone, as always, for your insights. We will be keeping a close eye on this as we wait for the closing arguments and, of course, the verdict. So, of course, our thanks to the panel of guests today for helping parse all of this out. As always, you can keep up to date with our trial coverage on king5.com and on our mobile app.